Q theory contends that the probability that the Supreme Court will hear a case on appeal increases as the number of Qs that are present increases. Some of the Qs that are commonly listed by scholars arguing Q theory include: 1. The federal government favors Supreme Court review of the case, or some high-ranking federal official, such as the President or Attorney General, publicly endorses the Supreme Court reviewing the case. 2. There are sharply differing or divided opinions expressed by justices on the lower court or between two or more courts in the appeals process. Appellate courts are generally composed of panels of judges. For example, the Texas Court of Criminal Appeals consists of 9 justices. Suppose that the Texas court hands down a decision in a case, but the 9 justices are split 5-4. 3 of the justices in the majority sign on to an opinion outlining a particular line of legal reasoning that lead them to their decision. The other 2 justices in the majority of 5 reach the same decision, but for a different set of legal reasons, which they outline in a concurring opinion. Finally, the 4 justices in the minority may write 1 or more dissenting opinions in which they lay out their legal reasoning that prevented them from reaching the same conclusion as the majority. If the various opinions are sharply divided on important legal or constitutional questions, the theory holds that the justices of the United States Supreme Court may take this as a cue that the case presents some issues that need to be definitively resolved. Similarly, as a case makes its way up the appellate process, if higher courts overturn lower courts and the opinions that are issued by the justices on each court are sharply divided, the United States Supreme Court may be more likely to review the case. Third, if a civil liberties or civil rights issue is raised by the dispute, the contemporary Supreme Court, going back 60 to 80 years, appears to be particularly interested in cases that raise questions about rights of free speech or free worship, right to privacy, rights of the criminally accused, or equal protection of the laws.